And what did we get? Did we get the client list? Did we get the tapes? Did we get the unredacted truth? No. In a shocking filing released quietly to the courts, the Department of Justice, Trump's Department of Justice, led by Attorney General Pam Bondi, made a stunning admission. They confirmed that they have released less than 1% of the files in their possession. You heard that right, less than 1%. But it gets worse. In a move that legal experts and members of Congress are calling a direct violation of federal law, the DOJ has explicitly stated they are asserting common law privileges to withhold documents, privileges that the Transparency Act specifically stripped away. They aren't just dragging their feet, they are rewriting the law in real time to keep these files buried. Why did the DOJ suddenly discover 2 million new pages of documents days after the deadline? Why were photos of Donald Trump on Epstein's jet posted to the DOJ website and then scrubbed hours later? And why are the very people who screamed "drain the swamp" now the ones building a dam around the most explosive evidence in American history? Buckle up. We are diving deep into the legal filings, the secret letters, and the timeline of a betrayal that proves one terrifying thing. The cover-up didn't end with Epstein's death. It's happening right now in January 2026 from inside the White House. To understand the gravity of this betrayal, we have to look at the text of the law itself. This wasn't a suggestion. It wasn't a request. The Epstein Files Transparency Act was a mandate passed by the 119th Congress with overwhelming bipartisan support. The act was co-sponsored by Democrat Khanna and Republican Thomas Massie, two men who rarely agree on anything, but who united to force the deep state's hand. The legislation was airtight. It stripped the Department of Justice of its usual excuses. Let's look at the text. Section 3, subsection B. It explicitly states that the Attorney General shall make publicly available all records, documents, and communications related to Jeffrey Epstein, Ghislaine Maxwell, and their associates. But here is the smoking gun. The act contains a rule of construction that forbids the DOJ from withholding documents based on, quote, embarrassment, reputational harm, or political sensitivity, including to any government official, public figure, or foreign dignitary. This clause is crucial. Historically, the FBI and DOJ have used privacy as a shield to protect powerful politicians, senators, princes, CEOs, arguing that revealing their association with a criminal investigation would harm their reputation. The Transparency Act made that illegal. If a congressman was on the plane, the DOJ must release the record, regardless of whether it embarrasses them or ends their career. The act gave the DOJ a 30-day window. That is an incredibly tight deadline in bureaucratic terms, but it was intentional. Congress knew that if they gave the DOJ a year, the DOJ would take a decade. They gave them 30 days. President Trump signed it on November 19th, 2025. That set the deadline for December 19th, 2025. So what happened on December 19th? Silence. The DOJ released a pitiful batch of already public court documents, things we had already seen from the Ghislaine Maxwell trial, the real internal FBI files, the interview summaries, 302s, the surveillance logs from Epstein's properties, gone, withheld. And then came the letter. On January 6, 2026, ironically the anniversary of another chaotic day in history, Deputy Attorney General Todd Blanche sent a letter to the presiding judge and to Congress. In this letter, the DOJ didn't just apologize for the delay. They admitted to a procedural failure so massive it defies logic. They claimed that despite having decades to organize these files, they had suddenly identified over 5 million pages of records that needed review. Think about that. For years, the FBI claimed they had looked into Epstein. Now suddenly, when compelled by law to release the files, the pile of documents grows by millions of pages overnight. This is a classic document dump delay tactic. Flood the zone with so much material that you can claim it is physically impossible to review it all in time. But the most incriminating part isn't the volume. It's the refusal to provide the index. The act required the DOJ to provide an index of non-disclosure, a list of what they are holding back and why by that December deadline. They didn't do it. They are holding the files and the list of files. They are operating in total darkness, in direct violation of a law signed by the sitting president. Let's get into the weeds of the excuse, because this is where the admission becomes truly incriminating. The DOJ is claiming that they cannot release the files because they need to protect victim privacy. On the surface, that sounds noble. We all agree that the underage victims of Epstein's abuse should not be doxxed. The Transparency Act agrees with this. It allows for redactions of victim names and personally identifiable information. But the DOJ is using victim privacy as a Trojan horse. In their January filings, the DOJ lawyers argued that they need to redact information to protect unindicted third parties. In legal speak, an unindicted third party is anyone mentioned in a criminal file who wasn't charged with a crime. In the context of the Epstein case, who are the unindicted third parties? They aren't just the girls, they are the men, they are the clients. They are the people who flew on the Lolita Express but weren't charged by the corrupted prosecutors in 2008 or 2019. By asserting a broad privacy interest for unindicted third parties, the Trump DOJ is effectively arguing that they can redact the names of the powerful men who visited the island simply because those men were never charged. This is a direct violation of the Act's prohibition on redactions for reputational harm. If Bill Clinton or a Saudi prince, or yes, Donald Trump appears in an FBI interview summary as being present at a dinner with Epstein, that is not a victim privacy issue. That is a matter of public interest. Yet, the DOJ is currently applying a presumption of privacy to these names. Representative Thomas Massie went on the warpath this week. He tweeted, "The DOJ is asserting common law privileges that the Act does not permit." What does that mean? Common law privileges include things like deliberative process privilege, the idea that the government can keep its internal memos secret so officials can speak freely. The Transparency Act was designed to pierce that veil. It demanded the release of internal DOJ communications regarding investigation decisions. Congress wanted to know why Alexander Acosta gave Epstein a sweetheart deal in 2008. They wanted to know why the FBI closed its probe in 2015. By asserting these privileges now, Attorney General Pam Bondi is essentially saying, we know Congress passed a law saying we can't hide this, but we're going to hide it anyway, using the old rules. This is an admission of lawlessness. The executive branch is telling the legislative branch that they do not respect the statute. And remember, the head of the executive branch is Donald Trump. This raises the uncomfortable question: is Pam Bondi going rogue, or is she following orders? If you think this is just bureaucratic incompetence, look at what happened on December 23, 2025. For a brief window, just a few hours, the DOJ uploaded a new batch of documents to their dedicated Epstein portal. Among them were flight logs and, crucially, photographs. One file, which was quickly downloaded by internet archivists and journalists before it vanished, appeared to show a photograph of Donald Trump on Jeffrey Epstein's private jet in the 1990s. We have known Trump flew on the plane. He has admitted it in the past, saying it was a lift from Palm Beach to New York. But seeing the photographic evidence in an official FBI release is different. It makes it visceral. It makes it real. And then, poof, it was gone. By the evening of December 23rd, the file was removed from the server. When journalists asked why, the DOJ issued a cryptic statement saying photos and other materials will continue being reviewed and redacted consistent with the law in an abundance of caution. Abundance of caution? Or abundance of panic? This deletion is arguably an illegal act. Once a government record is published under a transparency law, retracting it because it looks bad for the president is the definition of political sensitivity. The exact thing the act forbids. Furthermore, on that same day, the DOJ released a bizarre disclaimer on their social media accounts. They stated that some of the newly released documents contained untrue and sensationalist claims made against President Trump that were submitted to the FBI right before the 2020 election. Think about how insane that is. The Department of Justice, an impartial law enforcement agency, is issuing press releases proactively debunking evidence in their own file dump before the public has even fully read it. They are acting as the president's defense attorney, not as the custodian of records. This connects directly to the techno-fog and MAGA-sphere narrative. Influencers have been claiming that the Epstein files are full of planted evidence by the deep state to frame Trump. By scrubbing the files and issuing these disclaimers, the DOJ is validating that conspiracy theory while simultaneously suppressing the actual evidence. It's a win-win for the cover-up, hide the damaging documents, and discredit the ones that leak as fake news planted by the FBI. Let's go back to the numbers, because this is where the DOJ story falls apart completely. For years, we were told the FBI file on Epstein was substantial but manageable. In July 2024, the FBI claimed they had conducted an exhaustive review. Yet, in January 2026, Deputy AG Todd Blanche claims they have to review 5.2 million documents. Where did these documents come from? There are two possibilities, and both are damning. Possibility one, the FBI was lying before. They always had millions of pages of evidence, surveillance tapes, hard drives seized from Epstein's Manhattan mansion, the contents of the safe in the U.S. Virgin Islands, and they sat on it. They didn't process it. They didn't act on it. They let it gather dust while Epstein continued to abuse women. If this is true, it is proof of gross negligence or complicity. Possibility two, they are lying now. They are artificially inflating the document count by including duplicate data, system logs, and irrelevant noise to create a haystack so large that they can never find the needle. The DOJ admitted in their filing that a meaningful portion of the documents appear to be duplicates, but they claim they need time for a deduplication process. This is 2026. We have AI. We have advanced e-discovery software that can deduplicate millions of files in hours, not months. The idea that the Department of Justice needs years to remove duplicate emails is a lie. It is a stalling tactic, pure and simple. Congressman Khanna called this out. He demanded to know why the DOJ isn't using the same resources they used to hunt down J6 protesters to process the Epstein files. When the state wants to put you in prison, they can process terabytes of data overnight. When the state wants to protect its own, suddenly they are using an abacus and a magnifying glass. And remember, the act is set to expire. These laws often have sunset clauses or lose their funding momentum. By pushing the release into late 2026, 2027, the DOJ is hoping the public loses interest. They are hoping we get distracted by the next war, the next pandemic, or the next election. To understand the why, we have to look at the who. Attorney General Pam Bondi is not a neutral arbiter. She is a longtime Trump loyalist. She was on his legal defense team during the impeachment. She has a history in Florida politics, the same state where Epstein received his sweetheart deal. While there is no evidence Bondi was directly involved in the 2008 plea deal, that was Alexander Acosta, she moved in the same political circles in Palm Beach. Then there is Deputy Attorney General Todd Blanche. Before he was at the DOJ, he was Donald Trump's criminal defense attorney. He represented Trump in the Manhattan hush money case and the federal documents case. Think about the conflict of interest here. The man responsible for deciding which Epstein documents are privileged or private is the same man who was paid millions of dollars to defend Donald Trump from criminal liability. If Todd Blanche comes across a document that implicates his former client, the current president, in a crime, or even just in a lie, does anyone genuinely believe he will release it? The Transparency Act was supposed to bypass this. It took the discretion away from the Attorney General. But Blanche and Bondi are clawing that discretion back. And what about Trump himself? On the campaign trail, Trump promised to release the files. He said, "I have nothing to hide." He even encouraged Republicans to vote for the act. But now that the rubber meets the road, his administration is fighting the release. Why the pivot? Some analysts suggest Trump used the promise of the files as a weapon against Democrats, hinting that Bill Clinton would be exposed. But now that he is in power, he realizes the files are a shotgun blast that hits everyone, including his own social circle. The admission that they won't release the files is essentially an admission of mutually assured destruction. The DOJ knows that if they dump the raw files, the entire political establishment, red and blue, burns down. So they are choosing to break the law to save the system. The only glimmer of hope in this story is the fury coming from Congress. This is not a partisan issue anymore. Rep. Khanna, Democrat, and Rep. Thomas Massie, Republican, have formed an unlikely alliance. They have formally requested that the federal judge, Judge Paul Engelmayer, appoint a special master to take custody of the files away from the DOJ. A special master is an independent third party appointed by the court. If Khanna and Massie succeed, Pam Bondi loses control. Todd Blanche loses control. An independent arbiter would review the documents and apply the law strictly. In their letter to the court, Khanna and Massie wrote, The DOJ cannot be trusted with making mandatory disclosures under the Act. That is a scathing indictment. Two sitting members of Congress are telling a federal judge that the Department of Justice is essentially a criminal enterprise engaging in a cover-up. They cited the DOJ's failure to produce the index, their failure to meet the deadline, and their illegal assertion of privileges. If the judge agrees, and that is a big if, we could see a constitutional showdown. The executive branch, DOJ, versus the judicial branch, Judge Engelmayer, versus the legislative branch, Congress. But the DOJ is fighting back. They are arguing that the courts don't have jurisdiction to enforce a congressional oversight deadline in a closed criminal case, Ghislaine Maxwell's case. They are trying to dismiss the request on a technicality. This is the deep state in action. It's not a shadowy cabal in a basement. It's lawyers filing motions to dismiss on jurisdictional grounds while the shredders run in the background. What are they fighting so hard to keep hidden? What is in that 99% of unreleased files? We know about the black book. We've seen the redacted versions, but the DOJ has the unredacted originals. They have the phone numbers. They have the addresses. We know about the flight logs, but the logs we've seen are often handwritten and incomplete. The FBI has the pilot's direct testimony. They have the air traffic control records. But the holy grail is the surveillance footage. Jeffrey Epstein wired his properties for video and audio. His Manhattan townhouse, his Palm Beach estate, and the island were honey traps designed to collect blackmail, compromat, on the world's most powerful people. When the FBI raided Epstein's townhouse in 2019, they seized hard drives and loose media, CDs, tapes. Those tapes have never been seen. If those tapes exist, and if they show what we think they show, presidents, prime ministers, and CEOs in compromising situations with minors, then the DOJ's refusal to release them makes perfect sense. The release of those tapes would not just cause political embarrassment, it would cause geopolitical instability. The DOJ is likely arguing behind closed doors in classified SCIF briefings to Congress that releasing these files is a national security threat. This is the ultimate trump card. They will claim that since foreign leaders might be compromised, releasing the files would damage U.S. foreign relations. But the Transparency Act anticipated this. It has a section for classified national security information. However, that exemption requires a specific process. It doesn't allow for a blanket refusal. The DOJ is currently skipping the process and going straight to the refusal. Donald Trump ran on a platform of destroying the deep state. He promised to shatter the corrupt establishment. He signed the Epstein Files Transparency Act with a flourish, claiming credit for the disclosure, but actions speak louder than signatures. His Department of Justice, staffed by his appointees, is currently engaged in the most brazen cover-up of the 21st century. They are violating a law signed by their own boss. They are insulting the victims who have waited decades for the truth, and they are laughing in the face of the American public. The admission is clear: we won't release them, not because they can't, but because they are implicated. The 1% of files they released was a crumb. The 99% they are hiding is the whole cake. And as long as Pam Bondi and Todd Blanche are gatekeeping the evidence, we will never see the inside of that vault. The question is no longer, what did Epstein do? We know what he did. The question is, what are they doing to protect the men who did it with him? We are witnessing the final stage of the conspiracy. The conspiracy isn't the crime anymore. The conspiracy is the justice system itself. Do you think the special master will be appointed, or will the clock run out on the truth? Share this video. Tag your representatives. Demand the DOJ follow the law. Because if we stop watching, the files disappear forever.